have a question. Off nights meets at 6 o'clock today. Shall I make them later?
No.
We will be out here by 4:15.
I will do my best to be out of here in an hour or less.
Okay, thank you.
Okay? This is not a long process today. There will be future meetings that will be very long.
Okay.
But not today.
Not today, okay.
Okay, so I'd like to take roll call, please.
Cookie Booth board members?
Linda Zessinger, treasurer.
Perry Nixdorf, President.
Neil Hoffman, board member, present.
Jeanette Rinaldi, present.
Any staff present?
Gary Landry, present.
Gloria Alexander, office manager, present.
Deborah Blasco, accountant, present.
Annie Curtis, chief inspector.
Thank you very much. Okay. I do have a question. Are we recording this at the moment?
I am.
You are? Very good. Thank you very much. All right, so item number 2, comments by the general public. These would be comments not necessarily related to the items on the agenda. Are there any comments by the general public at this time?
Is that where I comment?
Not necessarily yet, no. Unless you want to talk about something that isn't on the agenda here.
No.
Okay. So item number, seeing there are no comments, we move forward to item number 3, consideration and approval of the agenda and its posting. Has the agenda been?
It has been posted in accordance with Nevada open meeting law.
Thank you very much.
Move to approve.
I'll second.
Vote.
Aye.
Do we have to have comments,
Yeah.
discussion?
Comments, discussion on the agenda and its posting.
No. Okay.
Fast. We're moving on here.
You like the gavel.
No, we got to get out of here in an hour, that's for sure.
All right.
Do this.
So here's where we take a little bit of time now. Okay. Number 4, develop and formulate a criterion by which each law to be reviewed will be evaluated for possible revisions. Obviously, there are plenty of things that we find inside in this book that are either unclear or out of date or something like that. So I'd like to sort of put together a little bit of criterion that says these are the clear criteria that we're going to want, because there are going to be some items that we just want to have and versus something that just needs to be changed. So I would like to start that by saying I think we should review any laws that are antiquated. Any discussion on that?
We should just say they're antiquated.
I would say they are antiquated because they are not enforceable, or their time is gone. You know, there are some things that are in the law books that, like for instance,
We don't do business the same way we did when the board was formed in 1931,
Right.
and it was a small group of board members, and they made the deposits, and they did this, and they did that. We don't do business like that anymore. And a lot of those regulations are written back then.
correct, some of the things
Right.
like the treasurer shall always
Yes.
make a deposit. Right?
Yes,
Well,
yes.
do that.
The verbiage is not,
I'm just asking, just
yeah.
they're making sure that everyone understands what it is.
Perfect. Okay. Is there a member that would like to add another criterion? Besides antiquated.
I think just bring into the 20th century is what,
Yeah.
instead of saying antiquated, just bring the law to the 20th century and to be applicable to today's, and maybe the future, try to kind of look out into the future.
Unconstitutional.
Well, I don't think we have unconstitutional because all the laws have already been passed muster as far as constitution.
You'd have, for a law to be deemed unconstitutional, a suit would have to be brought forward. You as a board, can't deem something as a
Wasn't there a
judgment.
suit against the American Mail a while back, or against Title IX? It was a Title IX suit. I'm gonna bring that, I'll bring that to the board, and they deemed it unconstitutional.
One thing you could do is you could say review any laws that we have had litigation on.
Yes,
That
review
would
laws
be
that
a
we have
valid
litigation on.
Okay,
And I
so-
know there
so-
has been.
So, litigated laws. That sounds good to me. How about laws that are unclear? and require clarification.
Laws and regs that are unclear.
Yeah, regulations, I agree with that.
Or verbiage that's confusing.
Yeah.
Confusing or redundant
Confusing verbiage.
Yes.
I like
We
that.
have that.
I like
Yeah,
that.
confusing and or redundant.
You know, I think as I read it, sometimes I can't understand it, so I think like the new hairdresser coming in, really, it's hard for them and make it so that the layperson can understand this as well as.
I'll read it and I'll go, I gotta call Annie.
Yeah.
I'm like, oh, no.
Okay, so confusing or what was it?
Redundant.
Redundant. All right. What else would you like to review some of these for? For instance, we had.
I think you might want to consider adding to the fining system, because I think I heard here in discussion today that you'd like to be able to sanction certain things. But before you can write a citation and put a fine to it, you need to put it in the regulations. And there are several of those that need to be added, I think.
So,
Violations need to be added to the regs that we
Yes.
can cite
Any
for.
activities that you would.
right, any
you would
new
want-
violation.
Any new
New
action
violations.
deemed a violation.
Any new action.
There are many that are not covered there. You know, the board does it now by saying you have to come back to the board because we may not allow that variance, we may not allow this and that. But this would put on the books in NRS a longer list of items that are of concern to the board.
Like the kiosks, we can't find a kiosk, so we'd want to
Right,
put something
we'd
in
want
there
to put
for-
something in place for that, absolutely, okay. Yes?
And we may want to revisit the regulations on your mobile units
Oh, yeah.
so that it wouldn't
Right.
have to be a completely established cosmetological full-service unit. Since we do have hair, skin, and nails. Because there are people that want to have a mobile unit for nails, a mobile unit for aesthetics. So we may want to revisit that. Or not.
No, I think we do, all right? I'm just trying to adapt that into a criterion.
Oh,
Could that be a
criteria.
variance
Any-
like the kiosk?
Not
and
a
then you're
variance.
fine?
Yeah, I think what you may want to do is you may want to say review any laws that require complete cosmetological services. And just review any, because most of the code says,
Yeah.
wherever you offer anything, you offer it all, and that's really not what's being done today.
Yeah, because we did that with licensing, you know, with nails and esthetician, hair
Yeah,
designer.
so you broke that out, so
So,
it might be time to go into the future and break some other things out.
Well, and I
Yeah.
think that's where we go to like the kiosks and so forth.
Yeah, you're on the-
And the whole point of the law review is to define it as a law, so we don't have to do all this variance.
Before you all the time.
Yeah, so.
Charlie?
Could we add the apprenticeship for cosmetology there? I always thought that should be reviewed for nails,
Yeah,
aesthetics.
I'm gonna take that probably under item number 5.
Oh,
Will you
okay.
give me a suggestion for that?
Mhm.
Right now, I'm trying to decide under the criterion. So, I think the criterion should be, should the law be separated or detailed, be
Spelled
made
out.
more detailed?
Made it more
Yeah,
detailed.
Made more detailed,
Yes.
which would break apart a broad
Which in a
general
break,
rule.
would a break out.
Define the definitions, basically. Define the
Yeah.
definitions.
Defined, yeah.
Define.
Yeah.
So I'm going to call that define broad general laws more clearly. Okay. Anything else that you can think of that's a criterion that we can apply to a law?
Maybe readdress the things that were nixed at one time, like, you know, something that was antiquated that got taken out that would be nice to be implemented back
So-
in, like a
All
shampoo.
right.
I
So
don't know.
we'll take motions to add things that are not currently in the law that are
Right.
a wish list.
Right.
We'll just put down a wish list.
I hear
Okay
a
about
lot
that.
about like shampoo people. You know,
Yeah.
I should have a shampoo
Yeah.
assistant, you know, and it's like,
Yeah.
they took that out, it's like, whoa, maybe we can have that.
Wish list, okay. So now let's take into consideration the 1,600 hours versus 1,800 hours. What criterion would we be applying to something like that?
educational requirements.
I personally wouldn't
Educational.
entertain any idea to have less hours, so I think it's a moot point to discuss it.
Well,
Continuing.
Sorry. That's how I feel.
I'm gonna vote it, I would go.
no, it's, would that could be considered antiquated, litigated? Well, I think litigated would be whether or not we, I mean, I have my, for instance, this thing with the makeup school. That's something that's being litigated, and how do we approach that? Advanced education, to me, I have suggestions on how we just take advanced education and just whoosh, push it out of the way, and we have nothing to do with it. But so that would be under litigated. But the 1,600 hours and bringing that into
It's the law that they would like to have changed. There's a group
Yes.
that would like it changed, there's a group that would not.
so
I personally think that we should have just one whole meeting on this where everybody, Las Vegas and Reno, can get together and have a debate on it, and then after they're finished, then we
We're
vote on it.
getting off
we're going
topic.
to,
Yeah.
correct. No,
Because
we're looking for
otherwise
criterion right now.
It was-
So I would say
That would be law, changing.
Right.
So
changing
let's put that under
All
the
we're
wish
trying-
list.
Yeah, all we're trying to do is establish how we're going to review the laws in this law review subcommittee.
Which,
But what
Right,
about when
so
you
that
wanna
we don't
change
go
one?
off topic too
right, and I
often.
think that this is, part of what you're doing is you're establishing categories. These are the categories that we're gonna set up, and so any change that's
Law change.
from the licensees, from the schools, from the, from the legislature, wherever, we need a place to slot it. And I think that's.
I'm also trying to do it so that if you read the law, that you can take this list of criteria and ask yourself, is this law antiquated? Has this law been litigated? Is this law confusing or redundant? Is this law a new action that needs to be deemed a new violation? Is this law too broad and needs to be defined in more clearer or more narrow terms or something like that? That's where I'm
Specific
trying to go.
language, so.
Yeah, so
Well, I think business prohibitive is important too, because I think that's one of the things that happened just recently with the makeup school.
is this a business prohibitive? Okay. I'm satisfied with this list. Is there anything else that anybody would like to add to this list?
I think it's a good
I
start.
have just, I am confused here, how are we going to bring them into this
They,
then?
number 5.
Oh, okay.
Next
so
item on the list.
Okay, but, so any law change, we're not going to be, that would be up to them to do the law change?
No, we're gonna bring it out and we're gonna
Okay, after we
discuss
listen to
it
them, okay.
and have lots of discussion regarding every single one of these laws
Okay.
that we have changed.
Public workshops, all of that.
That's good.
This is really, like Barry said, it's really, as we're looking down each law, does it not need to be changed? And if anyone thinks it does, a school, a licensee, the board, by what criteria would you say it is? And these are the 7 criteria that we're defining now. It goes into that bucket, and then we'll have a meeting, an entire meeting on laws that are antiquated. The following laws have been deemed antiquated. We're having a meeting on that.
Absolutely correct.
Okay, so we're not going to go section by section, we're going to go.
Not today.
No, I know.
Okay. By the way, yeah. Okay. So these are what I have. I have antiquated, litigated law, confusing or redundant verbiage, any new action deemed a violation, defined too broad, general law need to be made more clear, wish list, business prohibitive laws.
I think that covers about everything.
Covers it.
I think it does too. I'm good with that list. Can I get a motion to pass this?
I motion that the criteria established for the law review committee be following
The list we just
following 7 items you just listed out.
I'll second.
vote.
Aye.
Aye.
Passed unanimously. Okay, number 5. Accept suggestions as to which laws may need revisions. I have received from Mr. Green a list of items that he felt was important to make changes, that while he was working with Mr. Jimno, that Do you need a copy of that too? I've added some revisions to this, so this should probably be for you. And I would probably like to give one of these to you there. And okay, so I'm going to briefly go down this list so you understand what is already on the list. And if you have more things to add to this list, I will be accepting them at the conclusion of me writing out. I'm going to read this very quickly so that we all kind of get an idea of where we already are and what might else need to be changed. So, examination of hair braiders, NRS 644248. The reviewer said we currently test applicants for hair braiding licensure with NIC written test for braiding, which covers subjects such as hair structure not outlined in this statute. The statute as written only allows us to test on sanitation and Nevada laws. All the other statutes relating to scope of examination, such as cosmetology, aesthetic, nail licenses, etc., have the following language: such other demonstrations and tests as the board requires. Adding this language will keep our statutes uniform in their language. Okay, number 2, NRS 644300, notice to the Secretary of change of location. The reviewer's note is we currently do not record these changes of location and have not been requiring or enforcing said notification by licenses. Given the number of licenses in the state and sometimes transient nature of the business, this statute adds a huge burden on staff if they were to try and maintain records of every licensee's work location. And I'd like to add into there that additionally the Secretary doesn't actually get this notice. It should be modified to reflect the administrative process we actually use. NRS 644325, renewal of license, application fees, penalties for late renewal, photographs, instruction relating to infection control. The reviewer's note says we currently license individuals and establishments for a 2-year period. If we were to switch to a 3-year period, this would cut the workflow of paper down by approximately 1/3. For example, if we theoretically have 26,000 licenses we administer and they expire every 2 years, then staff are processing 13,000 on a yearly basis. By switching to a 3-year licensure period, this would reduce the yearly licensing workflow to approximately 8,600 per year. Additionally, there would be significant savings realized in the generation, printing, and mailing of forms, including the inherent costs of postage for said activities. Licensees would benefit by not having to repeat the process, take new photos, etc. every 2 years. Wedding services, NRS 644190, unlawful practices without licensing exceptions. The reviewer's note says every weekend in Nevada there are hundreds of both licensed and unlicensed persons working in hotels and wedding chapels performing cosmetological services for wedding parties. This has been an ongoing issue and has become unenforceable. We currently have exemptions from our requirements for photographers and their employees, as well as those working on motion pictures, TV, commercial advertisements, etc. An option for change would be to allow licensed individuals to be exempt from the place of practice requirement for these wedding services, with stipulations made to ensure the public is being protected with proper sanitation and infection control measures. This would keep the business in the hands of the licensees and weed out the unlicensed and potentially untrained operators who may be placing the public at risk of harm. The other side of this agreement is that ideally having a licensee work only in a licensed establishment is probably best for protection of the public in the areas relating to sanitation and infection control, as well as delivery services. However, these current practices violations which are taking place are rampant in the industry and the source of constant unenforceable complaints received by the board based on the fact that the business commerce is done online and services are done behind closed doors, not accessible to board staff. NRS 644377, food and beverage sales, and 644430, grounds authorized disciplinary action, orders imposing discipline deemed public records, specifically drunkenness. An issue that comes up frequently is the ability of licensees to offer alcoholic beverages to clients, and also the ability of the licensee to partake of alcohol while working. We currently have no laws or regulations prohibiting either, aside from the stipulation above that one cannot be drunk while engaging in the practice of cosmetology. There is a need for some clarification based on the board's discretion in how to address these issues. Animals in salons, NRS 644.472. Reviewers note, the Attorney General's opinion was written in 1985. Since that time, there have been many cultural and legal changes to this issue brought out by the Federal American with Disabilities Act. Federal law precludes us from requesting medical documentation when determining if an animal is considered to be a service animal. Service animals are now widely used for a myriad of disabilities and medical issues which go way beyond being visually or orally impaired and are not regulated to dogs only. Our statute on this matter should reflect the current proliferation of service animals and the superseding federal laws which are now in place to protect said usage. Service animals now go way beyond just being utilized for visually or orally handicapped persons. We are now encountering many seizure dogs as well as dogs used to reduce anxiety and other ailments. As soon as the person mentions the word service animals, we currently back off any enforcement actions based on the interpretation of federal laws.
But how does a federal law supersede a state law?
I don't know, we'll discuss that.
These
are items that...
State and federal?
Americans Disability Act.
The way they supersede is if they say that your laws are contravening the Americans with Disabilities Act, you will lose federal funding on multiple issues, highways, buildings, all of that. So that's how they typically control it with the pocketbook. Is how the federal does it.
It supersedes.
So NRS 644-331, registration of natural persons engaged in practice of threading and owners and operators of facilities in which natural persons engage in practice of threading, inspection of facilities by board, lease of space to certain persons, 644-307.
Why do they keep saying natural?
Natural? Yeah.
Well,
sometimes there are some unnatural people.
I'm just trying to understand why they keep saying.
I'm thinking because it's
I wasn't paying attention.
Right. Well, the premise of the law is that they're doing something that's culturally.
They don't have to be a license.
It's a cultural thing.
Well, that's how they based it on getting the law passed, was saying it was a cultural
But
thing.
it needs to be.
Even though all cultures remove hair, but it's a cultural.
So reviewers note, when threading was taken from our
Methodology.
jurisdiction, one issue was not addressed, which is the ability of registered threaders to practice inside of a licensed cosmetological establishment. Normally, any services outside of the scope of cosmetology must be practiced in a separate room inside the salon. This was never established within the law, and some clarification is needed as to the ability of registered threaders to practice on the floor of a licensed salon, or do they need to be in a separate room as other non-cosmetological services have been relegated. NAC 6440539, passing score. Hair braiders should be added to the above regulation. Shampoo bowl requirements, 644.330, plumbing dispensary sink floor coverings. Reviewers note, there is currently no regulation in place requiring a shampoo bowl in any salon licensed for hair services. We have enforced this requirement through the above regulation using the term suitable permanent plumbing. There could be better clarity of the requirements for salons licensed for hair services to have a shampoo bowl. Skin peels, NRS 644.470, treatment by X-ray prohibited, application or implantation of certain substances prohibited, penalty. Nothing in this chapter. Okay. Reviewers note, this area of cosmetological services has undergone significant changes over the past several years. Our laws in these matters were written many years ago, and technology, product development, and enhanced safety guidelines have now outpaced our laws and enforcement capabilities. There is a strong need for a revision of what is allowed and not allowed in these practices. Perhaps we could look to incorporate guidelines from the National Board of Aesthetics upon which we could model any changes. Our current laws lack the clarity and cohesion to regulate modern-day aesthetics as it is being practiced in our state. NRS 644020. This is those were given to me by staff. The following is what I went through and briefly came up with some ideas that I would like to see changed. All right. These are the definitions. There is no definition for School of Cosmetology in the NRS statutes. There are many things defined under this section. However, what a school is not. If a school was defined as a place for pre-licensed persons to obtain their education, it would open up the ability for advanced places of education to open up that are not regulated by us, since they would be only providing classes that are not needed to obtain a license from the state. NAC 644.025 could also be amended to clearly define that all rules related to schools applies only to schools that are instructing students to pass the state licensing requirements. I also think we can define student as a person seeking licensure and not have it mixed up with any person practicing cosmetology and seeking education. I thought that that would be a very easy way to bring about advanced education in our state. Issuance of license 644260. I thought this is sort of related to what you guys were talking about, and I thought we could make changes that allow any student to challenge the test. The statutes that apply are all kinds of them that say that you have hours and so on and so forth. And I would like to see us discuss language that allows a student to challenge the test, since we're interested in having qualified individuals. And if a person or a school could get them to pass the test faster, I think we should have that option available. But we'll discuss that. Approval of device used in cosmetology. This is antiquated and unenforceable by us, so it should be eliminated. NRS 644130, record of licenses, disclosure of information. Subsection 1, which is that we keep a record of a known place of business. It's not as doable as it used to be. The known place of business is impractical and is not useful, since we use whatever mailing address the licensee gives us to contact them. This goes along with the earlier staff recommendation that be revised a bit. So if we just eliminate known place of business and keep the rest of it, I'm good with that. Deposit of fees, 644170. Deposit of fees, receipts, expenditures, delegation of authority to take disciplinary action, deposit of fines imposed by the board, claims for attorney fees and costs of investigation. Subsection 1 is antiquated. We no longer have the treasurer to do the deposits, and we get our reports quarterly. The law should reflect actual administrative procedures we have in place. Instructors' qualifications fee for license. This would be 644195. I took a guess at this, right, because it's kind of difficult for me to envision that you guys actually can do this. Subsection E is not practical. Subsection E specifically talks about us approving advanced units of education, or say, except as otherwise provided in subsection 2, take one or more courses in advanced techniques for teaching and training approved by the board, whose duration is at least 30 hours during each 2-year period. I'm not sure that that really is followed, and I'd just like to know about that, and if it's all done and it's all workable, then I'm okay with it. But I thought that that should be looked at, because it's not practical. Electrologist defined. I think we should remove electrologist from the jurisdiction of cosmetology entirely. I think this person has nearly become extinct. There are only 4 registered in the American Electrology Association in Nevada. Across the United States, only 6 cosmetology boards regulate them. I believe that a discussion of this is in order. Those are the ones that are between the staff and myself. I will now entertain any NRS changes that you all may have that are near and dear to your heart.
Harry, can I ask you a question? So what you wanted me to go back and read these and see and be able to discuss them at the next meeting? Is that what
Not all of them, no. I'm going to pick a few.
Okay.
And
okay.
no, we're going to pick like 1 or 2 or 3.
I have a real job too.
Yeah.
Okay.
We will keep these meetings to
Okay,
4
gotcha.
hours
Okay.
or so is what I think is what I'd like to do.
Okay.
So we'll be taking these individually over the next year and a half
Okay.
and discussing them in detail, allowing for lots of public comment, and
so
doing what we got to do to make these very transparent and very coordinated cohesive between all of us, right?
Okay.
So that we
So
can come up
you're
with
going to
something.
tell us which ones to study, and then we'll go back and read it, and then everybody will come back and discuss it.
In detail,
In detail.
all noticed,
Okay,
so that
gotcha.
everybody will know this is the law we're going to be talking about. If
Okay.
you've got an issue with it on one
Perfect.
side or the other, please come talk to us. That's all fantastic. Right, what I'm asking for right now are additional laws that I did not read out that are near and dear to your heart. We'll start with us board members, and then we'll go to the public.
Give me a second, because I had something written down here, but I think this is a different book than when I wrote it, so I gotta
That's
find
okay.
it.
I'm going to be sending you, I will email you everything that I have.
Okay,
And I've been
which will
compiling.
not be redundant to the ones.
It will
that-
not be redundant to the ones that you have on there, no.
Right.
Okay. Neil?
You covered what I was interested in changing with the list you gave.
Okay.
I'm just here to listen.
Koki?
I think you've got some of the stuff here and we can bring stuff up in the future, right?
Yes, we
This
can.
isn't a one-shot deal.
It is not a one-shot deal. It is basically a starting point.
This is, I got a full plate right here.
Yes, it is. Mr. Landry, do you have any?
One thing that came up at the NIC conference is something we should address and at least start discussing, and that's laser technology. The state of Arizona is very advanced in that area, and we can get their statutes, so that's something I would like to start a discussion on. The other thing is...
That would be under wish list, basically, so
Yeah, this-
laser technology?
Yeah, this is just when you talk about new laws or things that need to, things that are antiquated, we don't address laser technology at all in our statutes. So that's something, and then also just as a point of information, my plan is to get all of the laws from all 50 states that cover cosmetology and have that as kind of a law library for us to use as a reference. So when we are discussing these, we can see what the rest of the United States does. And when we find one we like in particular, I can actually contact an executive director and get some feedback on what would they change in their existing. If we're going to pattern ours after their law, what's wrong with their law so that we don't run into that same problem.
I would value that opinion greatly.
Yes.
Any for you? Any for you?
Annie, do you have any more?
Now's your
Okay,
time.
was that laser? Did you say laser?
Technology. That would
Which
be hair
we-
removal, laser
Oh.
hair
We
removal.
we approved as a board.
Because I think that's under
not the last meeting,
that's
the
under
meeting
prohibited
before,
practice in here.
The 2 meetings ago in Vegas, we approved an LED light therapy. So but we don't have any regulations.
Right, that fell under the approved devices.
Right.
Right.
And which I think, with the way technology is these days, nobody really is going to stop and ask the state board, is it okay if I sell this stuff in the state? No. Put it on your list. It's like, not so much.
Okay, these are the some suggested findings changes for regulations. You want to-
I'd love to have
in
it. I
blue
was
are
hoping
the
you'd give
changes.
me these, because I didn't put them on my list, hoping that you would give me this. I thought we might cover it during the budgetary, but you guys didn't need to have added money attached to the budget work, so. All right, now, time for public comment. If there's any, oh no, Charlene.
My only thought, because I do the apprenticeships here, I've only got 4 current ones, which is the lowest number I've ever had. I'm constantly getting requests for nail techs or estheticians for the rural areas, because again, there's no schools out there for them. And I don't know if that's something that can be looked at and maybe thought about. We do double the hours for the cosmetology apprenticeship course. I assume you probably want to do the same for the others, even hair design. But just a thought to put out there to look at some point.
No, I agree. I personally have an issue with the 60 miles, but
As discussed in previous
as discussed in previous meetings. But thank you for bringing that up. It was more of a personal issue on my part than it was a broad question. But if you're having issues with that, I would love to bring that up as well and discuss
Well,
that.
just a thought. I mean, it's not going to be any harder than the Cosmo one, that's for sure.
Correct. No, that one goes under reviewing under defining broad general laws more clearly is what that
Breaking it
would be
down.
for apprenticeship.
Breaking it down.
Breaking it down some, yeah, exactly.
I have a possible law that I'd like to look at. I don't know, I think it falls under this law. I think it could fall under this law. But I think barbering has really come into being really hip right now. I have this business concept that I'm working on, and I'm just really thinking it's really hard to find barbers, because there's only one school down in Vegas. And so there's no barbers anywhere around here, except for hither and miss. It's not like you can go and get barbers from somewhere. And so they restricted us, the barbering board, from shaving. However, we are allowed to remove the top layers, the outermost layers of the skin. We are using a straight edge on the neck with a guard. I don't see why we can't pursue that and take a look at that.
I have a question regarding that a little bit.
Good.
You said they restricted us from shaving.
Yeah.
Do I see anything in here that says we can't shave?
Okay, it's under their law 643.
Their law.
We only have one law that says we can't predominantly do males or men.
Correct. That's what
Okay.
the law I read that says
But
we can't
then
advertise to men.
it refers you to their law, which is 6443. And in their law, it says we can't do barbering.
Their law says that nothing applied to nothing in their. I just read it yesterday. Their law says that none of their laws apply to us. It's right up front.
We need Sarah here because I would.
No, I just read that. Hang on one second. Did I?
And then
say
as far
that?
as advertising goes too, there is a
didn't
law that
say that.
says under
Yeah.
wigs that says we're not
Well, that
allowed
was the
to.
intention when they put it into law.
Right. To
Put the
me,
644.
it's about the purview of 644 and theirs. If it's not in our laws,
Actually, their law is referenced in our law
where?
under
'Cause that's
four.
what
I think it's
need to know
476.
To be able to.
NRS 476. Let me get that.
Under
I
pressure.
think that's it.
Find it.
476 unlawful to copy alter license.
Wait a minute. It's in that area.
Unlawful acts concerning cutting of men's hair and
Okay,
practice of
that's
barbering.
it's 473.
Yeah,
Yeah, NRS
473.
643190.
And then they refer you to their law, which is 6 and 7 of NRS 643, which is their law. So this law ties into the statement that's in their law, which say we can't shave.
But then we're not really.
Well, then
You
this
can't
is
do any
definitely-
barbering.
Okay, I think this is definitely something we should look into. Let's add it
Okay.
to the list.
But that's what that intent is.
Yeah, I think we should
And I
definitely.
wonder when that was written.
It was written in 2005 was the last time it was
Looked at.
looked at, and in 1969 is when it was added to the NRS. So it's been a long time.
Yeah.
So I definitely think we should look into
Over 40 years.
Annie, do you know the law about wigs and you can't advertise?
Pardon?
They can't tell you how to advertise. There's
it.
a law
let
about
me-
wigs in
It's the
here.
same one.
That's an Attorney General's opinion. It's in the front part of the book.
Yeah,
It's under. In other words, we can't do okay. It's a regulation of advertising. It's on 10.
Page 10.
You can't prohibit. It's on page 10
page 10.
at the top.
Okay, should be page 10.
Where it says regulation of advertising by State Board of Cosmetology.
The
Right.
State Board of Cosmetology may not completely prohibit certain advertising by a cosmetological establishment, see NRS 6440225, but may adopt regulations that would require cosmetological establishments to disclose in their advertisement those services which are licensed or regulated by the board.
Right, so this, I think it's business prohibitive to tell me what I can advertise and what I can't advertise. So I'd like to be addressed.
So
Or
that would...
anybody, like
okay.
if I want to
No, that-
advertise wigs or whatever I want to advertise.
Right, so according, that is an Attorney General's opinion under NRS 6440225, which is cosmetological establishment defined. Cosmetological establishment means any premises, mobile unit, building, or part of a building where cosmetology is practiced other than a licensed barber shop.
That's part of the
In
litigation.
Which, right, in
Mhm.
which one or more licensed male technologists practice.
There was a case in it that.
Wig salons need not be licensed as a cosmetological establishment, even though the setting and styling of wigs is performed therein by licensed cosmetologists.
I remember that, but I'm interested strictly in this advertising issue. I mean, I think it's business prohibitive, and I think if we do it, we should be allowed to do it if it's in our scope of practice. We should be allowed to advertise to whoever we want to
State
advertise
Board
to.
of Cosmetology may not completely prohibit certain advertising by a cosmetological establishment. So my question is there a law, well there wouldn't be because we cannot prohibit advertising by a cosmetological, but may adopt regulations that would require cosmetological establishments to disclose. Do we have a law that we have adopted?
No,
According to
what-
that? I don't
I
recall.
would suggest putting, for expediency, I'd suggest putting it on the list.
Let's do
And
that.
then just
Okay.
discuss it in detail once we get
Sounds good.
Attorney General.
644-0225.
Why is it that they can tell us what not to do? Is that something that just happened in years and years and years ago?
Evidently, someone asked the opinion, and they gave a legal opinion that they put in the book. But the intent was that if you are licensed under cosmetology, you do not want to misrepresent yourself to the public. You can tell them what you do. That's under that jurisdiction. If you're doing something else inside there, let's say, for example, medical, you cannot advertise that and have the main thing on the front of your cosmetology establishment. So they want the public to be real clear of what they're getting out of that establishment, is what the intent
So
was.
something like a medical spa or something.
Right.
Okay.
Right.
So that's
And
why
it's
it was
defined
there.
What's a medical spa, what's a, medical
right.
esthetician versus.
Barbara
Okay.
colors
So we'll
right?
we'll go under that, no problem.
Okay,
We'll-
just do everything,
we'll do that.
don't
I think it's important.
All
they?
right.
Any color hair, perms,
Something.
Yeah.
Anything else? Anybody else have any laws that they want to add to this list at this moment? All right. Your turn.
All right, I want to amend 644-200 under section 5, subsection A, for the 1,800 hours to be reduced to 1,600.
Did you get those stats you said you were gonna come back with?
I did. Well, they're from Utah.
They're from Utah?
Well, it's the verbiage that they use for to amend their law.
No, I was saying what the percentage was that you lost.
Oh, us, 10%. So.
I would, I'm all about having this discussion, because I'd like to see the challenges and, there's lots of things that I'd like to see that are related to this. So I'm all about the discussion.
I'd like
So-
to add something though.
Excuse
In
me.
the discussion, when it comes to before us next time, I think it's important that we have some sort of information that how would you reduce the hours and what that would look like. Because as they're coming to me now, and I should say for the last 20 years, they're ineffective. So it'd be really nice to know how that's going to be transitioned with less hours. Because I don't see it.
It's all good. This is a very highly controversial
It is.
subject
It's
that
frustrating
you're
for
going
me.
to have us review, okay? So I would suggest you get your camp in order, right? So that you have a camp of people that are going to come and say, I agree with you, and Rodney will get his camp in order that says, I don't think so. And please get your camp in order, and we will give everybody their fair share of time to discuss the pros and cons, both here in northern Nevada as well as in southern Nevada, because we will be taking this up. This will probably take easily 2 meetings, just this one alone.
Just for a subcommittee?
For us, yeah. This will be one in northern Nevada, one in southern Nevada. Enough, I think this is a super important issue that everybody needs to be able to talk about and talk about thoroughly and completely so that everybody feels they've had their say. And so.
Mary,
Excuse me.
we can't take it forward for at least another 2 years.
Oh, I know that.
No, we know that, but this is
I mean, I just wanted her to know that.
Oh, I do know that.
I just was going to mention that it might be a good idea when the public speaks to say their name for the record.
Got it.
I would have no
Amy
idea.
Christensen?
Amy Christian.
Thank you.
Is there anybody else in the public that would like to have a law change that they feel is, that needs changing? Yes, sir.
I just had one question regarding this.
This is Mr. Raffio, correct?
Correct, thank you. Yes.
Thank you.
Let's just say for conversation's sake that the board feels positive about a reduction in hours, which I know right now that's not the case necessarily overwhelmingly, but let's just say it was. How does that work? Because the legislature has to make the change,
Correct.
right? The board can, if it wills, make a recommendation to that effect? Or?
That is correct. The intention of this committee is to show the state legislature that we are proactive about what we're doing, and that we're trying to create a review of all the laws so they can do this in one fell swoop. We want to show them that we have had public input, that we have done our due diligence on all of this stuff. I intend to have pretty specific language so that they don't have to, this other thing that we had is pretty broad language. I want very specific language that we're going to suggest that they use, so that it makes it as easy for them to digest and gives them the perception that we have done what we need to do to bring forth these changes and that they need to be done. Once we give it to them, next year, what happens is we give our suggestions to the governor, and the governor says, no time for it whatsoever, and everything we've done for the next year and a half doesn't happen at all. And then we have to do it for the next time. Or you can go to your legislator and say, I think this needs to be done, just like some of these laws that are forced upon us, like hair braiding and things of that nature, right, that we didn't ask for, but somebody asked for it. That, our duplicate license is an example that we're dealing with right now. We didn't ask for it. Somebody came forth to their legislator and said that. So you will have that opportunity. We will be discussing with you and letting you know how that goes. Once we get our, you're going to see everything. This is supposed to be a very transparent committee on my part. And then we'll let you know, hey, the governor said, no, we're not going to let these go, or we're going to let this one, and this one, and not those, because they sat down and worked it out. And then you'll have your opportunity to go to your legislator and say, this issue is important. The board won't be able to bring this forward because the governor only has so many laws that he can bring forward for us. So it's a process, and I want you to be very involved in the process so that you get what you need and we get what we want, and the board and the public in general is better served.
It's very odd to me, understanding our Constitution and giving individual states the rights to set their own laws and regulations for the most part. It's still very odd to me that the disparity in hours. We used this morning the example of New York with 1,000 hours, and maybe Florida, maybe less. I don't know.
It is a big problem across the
2,300.
It's a big problem across the United States because there are boards nationally as well as in individual states that have nationalized standards, and boards of cosmetology across the country don't have a nationalized standard. The NIC, the group that we meet with, is specifically trying to make that happen so that we have a nationalized standard, so that we have a level of professionalism in our profession that's not currently being attained, that the board of nurses, the pharmaceutical reps, the medical examiner, there's all these different boards that have national standards that we don't, that we're trying to, this is the basis for a lot of why we're discussing, a lot of things that we're discussing is a national standard for what's acceptable.
Right.
So, and the answer to your question is yes, we do have the ability to submit what's called a BDR, or a bill draft request. Most boards can do that. You also can do that through your individual legislators if there's a law that you want to champion as a cause that you want to change. So,
okay. So is there any other specific laws that any of you would like to see us review? All right.
Well, I'd like to keep it at 1,800 hours just as a matter of record, so.
That'll be good. We'll have plenty of opportunity to make those comments and discuss pros and cons. Absolutely. Right. I intend to make this a very big deal.
I'd like to tell you something. You know, you scolded me over where were we when this thing came down from the Department of Education. Well, I was there on that braiding thing. I was in the senator's office, and I was listening to the senator scold Gemini, or whatever his name was, for not going through the process. I was there when that was happening. Me and Sandy Dunham and Gwen, and the three of us were in that office while that was going down. So, you know, you said you don't understand how that braiding law got put through. I don't either, because we were in there fighting it.
Exactly. So, I mean, our chances of getting any of this legislation is hit or miss, really. I mean, we just want to put forth concerted, well thought out revision to our Chapter 644. And we hope that the legislator will look at it, the legislation will look at it that way and say, okay, we'll take a look at it and we'll make some changes for you.
Harry, can I say one thing too? I think what this whole team up here wants to do, we want to go forward as a team. We want to work with everybody as a team, and that's
Correct.
what we're asking of you, to be part of our team, and we want to be part of your team.
Correct.
So hopefully we'll be able to change some of these dynamics.
And we hope the legislature will see that as a team effort and will pass these laws but there are no guarantees, obviously. Right? Okay, moving on. There are no more submissions to this, correct?
Correct.
All right, we move on to item number 6.
One thing, Perry, before you move on, just to let the public know that at any time during this process, if you see things that you've finally gone through and looked in more detail, please get them in either to, where do you want them collected? If you want them to come to our office, we can collect them.
That would be the easiest thing. Submit them to Mr. Landry, and he will forward them to me.
So you can submit to our office, and we will slot it in for discussion at the appropriate time.
Or bring it to the next meeting, or however you feel is most appropriate. It's all good. During the entire time that we're talking about this, we will be accepting new submissions and so forth. All right. So if you see something and you go, oh, that's not right, let me know. Okay. All right. Establish a subcommittee meeting schedule for the upcoming year. So my thoughts were, I'd like to dedicate about 4 hours per meeting. It'll take a few meetings at that, but I'm not all about these 8-hour meetings talking about a single law, for instance, you know. So, can I have any suggestions from the board how often they would like, or from this committee, how often they would like to meet?
Once a month, is that enough?
I would think once a month, 4 hours once a month would be. Shall we exclude the months that we actually have a board meeting, or just keep it right on going?
I think we should include it with our board meeting, for that month.
There are times when our board meetings have gone on very long.
Yeah, but they're
Such as today, really. I mean, we'd be out of here at 7 o'clock at night.
Usually we're out by 1, 2. All right. Just a suggestion.
I know. I would like it too, because it's cost savings.
Yeah.
There's a lot of benefits to adding it
Make
to.
it a 2-day.
We could do that.
We could do one day, one of it, would save costs on going back and forth, and on those times that we don't, then we can always do it in Skype.
But don't you guys usually Monday, because you guys don't work?
Right. So we can do,
So if you do
we could
2
do it on a
days,
Sunday and a Monday.
I'll work Sunday and Monday?
We could do it a Sunday and a Monday, if you wanted to. I mean, it's up to you.
I
That's
thought
a
they were going to be a
suggestion.
video.
Suggestion.
Video.
Monday through Friday, right?
Yeah, I would think, because we want them open to the public.
Yeah, I think Monday through Friday would be good. I think during business hours would be good.
Yeah, because that's going to allow, if you keep to the Monday through Friday schedule, it does allow for us to have video so that wherever you're meeting, whichever end of the state, the other part of the state can also participate. The other thing is you could actually set a tentative schedule, and if we see a board meeting is going to be, a lot of items, you have 22 items today. If we have a board meeting that we're going to have 10 items and there's no citation, none of the legal proceeding type things, we could make a determination at that time as we get closer. And you could actually throw in another meeting that the noticing requirements, the absolute minimum, Debbie can correct me if I'm wrong, 3 days.
3 days, by 9 a.m., 3 days
Yeah.
prior to the meeting.
So if you had to have another meeting, it's not a big deal to get another meeting put in there from scheduling. I will be checking and giving you advice on the video conferencing centers and their availability. So that's one of the things we have to do.
So just to throw out a date out there, let's say the second Monday of every month, 9 a.m. to 1 p.m. Anybody?
Does that work Skype? Does that mean we're traveling back and forth?
It will be always Skype, video conferencing. There will be no traveling of board members to go to these committee meetings. The only traveling will be when they fall on a board day.
I thought they'll be traveling to go to like UNLV or something like
That kind of traveling, but within town.
Within the community.
Yeah, you won't be required to come to Reno for this, and we won't be going to Vegas.
So are there gonna be set hours, like this time to this time?
9 to 1,
9 to 1, okay.
the
so
second Monday of every month.
So you want to meet again next Monday?
No. Starting in June. That would be June 10th, July 8th, August 12th, September the 9th.
But you'll send us a schedule?
Yes,
Yeah, okay.
just tentatively, I'm just throwing out the dates. October 14th, November the 11th, December the 9th. To my knowledge, that doesn't conflict with any holidays or...
Actually, November 11th.
Pending that we
Is
can get
November
the-
11th is Veterans Day?
that we can
Okay.
get the rooms.
So then we could, maybe we could do it on November 4th or something on that month. We will change it.
But we have a meeting in November. I think it's that first Monday, so we can combine the two.
That would be good, okay. So tentatively, is there any discussion on using the second Monday of every month, beginning with June and having November 4th? All
Send
good?
out a schedule, we'll throw it on the calendar.
All right. Do I need to vote on that? Can we just say that's the schedule?
I motion that we schedule the law review subcommittee meetings to proceed every second Monday of the month, with the exception of the month of November, when there will be a conflict with Veterans Day.
Second?
I'll
Second.
All in favor?
Aye.
Aye. Anybody opposed? Passes. Okay. Comments by the general public in general. Seeing there are no comments by the general public, move on to number 8, adjournment. A motion to adjourn?
Motion to adjourn.
Second.
All in favor?
Aye.
Okay. Meeting over. Thank you very much, everyone.
Thank you.